Welcome to Liberty Law Talk, part of Liberty Fund's online library of law and liberty. Your host is Liberty Fund Fellow Richard Reinsch. Our website is libertylawtalk.org, where you can subscribe, comment, find other episodes and links relevant to today's conversation. Our email address is mail@libertylawtalk.org. We'd love to hear from you. Todd Zywicki is George Mason University Foundation Professor of Law at George Mason University School of Law and Senior Scholar of the Mercatus Center at George Mason University. He is a frequent commentator on issues of bankruptcy law, consumer credit, and lending issues, and has been out in front on the topic we're discussing today, as well as issues associated with the Dodd-Frank Act. Professor Zywicki, welcome to Liberty Law Talk.
Thanks, Richard. It's great to be here.
Great. Todd, let me ask you. It seems to me there's a public consensus around the bailouts at this point that at worst, maybe the government lost some money, but it wasn't that bad. The companies have been rehabilitated, and they are at least are in a position to, participate credibly in the market. And at best, there's actually a good story here. They're profitable. They're contributing to the city of Detroit. They're contributing to other areas where they're operating. The employees are, gainfully employed. Their pensions, their health benefits are all rolling. So really, this isn't such a big deal. We shouldn't really be worried about this. Let me ask you: Are there reasons to doubt both sides of this? That it's not a bad deal. It's been a wash for the taxpayers, or it's actually been something that's a net positive for the country?
Well, I think that message is quite wrong and quite dangerous. Which is, I think that if you look at what happened here first. If you understand how bankruptcy works and what would have happened in Chapter 11, most of what happened in these cases is completely unnecessary. I think second problem was that they shredded the rule of law in the process, which will have long-term implications for economic growth and the economy. Third, I think that by politicizing the bankruptcy process the way they did, they actually left the companies worse off than they would have been by basically putting political hands into the game. And finally, I think that what we're seeing now with what President Obama has said about it and the way it's been played in the mainstream media is it sets a very dangerous precedent in terms of the role of government and in the economy, the role of government in creating circumstances under which moral hazard can prevail. And so I think in the long run, it's a very dangerous precedent, and that's why I've been interested in this, is to explain what went wrong here so that we can learn the lessons and we can actually avoid the kind of problems we had here in the future.
It seems, and surely, the way I envision this playing out over the next, 6 or 7 months until the election in November, is something like a claim being made that if we had not saved these companies, then something like, if not economic chaos for the regions and these employees, there would have been an enormous amount of stress placed upon government, particularly local and state governments, for all these displaced employees, and in particular, all of the umbrella industries and factories that figure into the domestic auto markets. Let me ask you this question. Was there another alternative? Was there a better alternative? You mentioned that the companies emerged worse off after the government bailout, but what option was there, given that the companies didn't even seem to be really preparing for a bankruptcy process to begin with?
Well, that's one of the things that you see that's so obnoxious about this in some sense, is that the companies themselves, especially General Motors, was incredibly arrogant going into this process, which is that they basically held the American economy hostage and were very brazen about saying, we are making no preparations to even consider filing bankruptcy in order to raise the threat, basically, of a sort of a self-fulfilling prophecy that any bankruptcy that was filed would have been a messy bankruptcy and would have brought about these results. And I think that is bad enough. I was very happy when finally in the spring of 2009 these guys finally got into bankruptcy, because I thought it would bring some order to what they were doing, and instead we got this political process. And I think that myth, it's really a myth that this would have led to the collapse of the American automotive industry, and the reason is that it rests on a fundamental misunderstanding of how bankruptcy works, which is that I've been teaching bankruptcy law for 15 years, and the example I've always given of a firm that would do well in bankruptcy, for whom bankruptcy is designed, is General Motors. And basically what bankruptcy does is it distinguishes between two different types of problems with a business. On one hand, you would have economic failure, and on the other hand, you'd have financial distress. So what would be an example of economic failure? That would be, say, if Smith Corona Typewriter Company were to file bankruptcy, there'd be no reason why we would reorganize that company. Why? Because that company is basically worth more dead than alive these days, which is to say we're better off liquidating the company, redeploying the human capital, physical capital, and financial capital elsewhere in the economy. For a company like General Motors, though, it's clear that there's value there. It's clear that they've got going concern value. They've got a unionized workforce. They've got highly skilled workers, equipment. They've got value there. They just have decades of mismanagement, and they needed to straighten out their liability side of their balance sheet. But it's clearly a company that's worth more alive than dead. So the idea, and that's what bankruptcy does, is makes those divisions. And so the idea that General Motors would have liquidated, for instance, and that there would have been a collapse in the American automotive industry is just simply a myth.
So your point is the economic logic within Chapter 11 of the Federal Bankruptcy Code accommodates both Chrysler and GM in this specific moment. I mean, there's no reason to think it would not have worked.
That's exactly right, Richard. And we've seen this. We've seen department stores and airlines and all kind of different companies go through Chapter 11 and reorganize successfully. And that's what would have happened here very, very easily. The only argument that's really been made to justify the bailout was the notion that capital markets and lending markets were not working very well at that time, which is a plausible argument. And so I think a credible argument could be made. We'd need more facts, but one could make the argument that maybe there would be a role to help with that problem, because it's clear if capital markets were working well, General Motors would easily get what is called debtor in possession financing to operate in bankruptcy. And if that wasn't forthcoming, it would, which would be plausible given what was going on with the markets at that time. But even if you acknowledge that small role for the government, that does not in any way justify everything else that came about that I've alluded to already. The violations of the rule of law, the attack on the secured creditors and Chrysler, the politicized management of these companies, and all the political finagling that went on with respect to these companies, the preferential tax treatment, and everything else that flowed from that. You can buy that small little premise, and that's what the Obama administration has glommed onto to basically justify all the other outrages that came about in these cases.
So you've talked some about the economics behind this process, or I guess we should say, rather, the bad economics of it. But there's also, of course, there's the legal cluster of issues that surround the bailouts, and you being an expert in bankruptcy law, what had to happen to make this possible that seemed to contravene normal practices of bankruptcy law that are followed in these sorts of cases almost without question? What were the specific steps taken that left a lot of people with a bad taste in their mouth?
Well, there were some really egregious violations of the bankruptcy law here. And one thing to keep in mind is that the bankruptcy laws are basically subject to the rule of law, right? Which is that we know what the rules are in advance, and people then can take that into account when they're lending to begin with, or when they're figuring out what the rights are in bankruptcy. And there's a couple things that were really huge violations of the rule of law in these cases. The first was what is called the absolute priority rule. And what the absolute priority rule says is that senior creditors get paid before junior creditors in a case. So, for instance, Chrysler, because it had been so mismanaged for so long, was primarily funded by what's called secured credit, which is creditors actually have a right to take certain property in the event that the borrower doesn't pay up. So, for instance, that would be like the mortgage on your home or your car lender. They have the right to take your house if you don't pay up. Secured creditors get paid before unsecured creditors, which is just a promise to pay, for instance, like your credit card bill would be. What we saw in these cases was that in Chrysler, there were a lot of secured creditors, bondholders, including people like the Indiana Teachers and Firemen's a pension fund, who had bought these bonds. And in exchange for, because they're lower risk, because you're a higher priority creditor, you get paid a lower interest rate than you would if you were unsecured. Those guys were secured. The unsecured creditors in these cases were the United Auto Workers, who had there were shortfalls in their pension plans and health benefits and that sort of thing. And what we saw in Chrysler was the government intervened, came in, and basically gave the senior creditors, the secured creditors, 29 cents on the dollar, and the UAW about 44 cents on the dollar of their claims, which totally turns that on its head. Another thing that's troubling about that is that there were secured creditors in General Motors as well, and the government did not mistreat the secured creditors in General Motors, which leads you to believe that they didn't even have a principle behind what they were doing in Chrysler. It was simply that it was expedient and necessary, they thought, to browbeat these guys into submission.
That's interesting. That seems like such an egregious violation. How would that happen? I mean, are there other factors at play as well? I mean, you've already mentioned, one way to perhaps justify the, shall we say, deviation from this process is the lack of liquidity in the credit markets as well. So are the other firms, the people that would have been or that were secured creditors, how are they compromised in this process, it seems, to not actually fully vindicate their rights? I mean, if this is a long-standing practice in the bankruptcy code, it seems it would be an open and shut case. What am I missing?
Well, if you recall, what happened was President Obama gave this extraordinary speech at the time where he went out and basically what you had were two groups of bondholders in Chrysler. There was a group of what were called sort of holdout creditors who decided to stand on their property rights. And you may recall President Obama gave this extraordinary speech where he tried to browbeat these guys into submission and say everybody needs to sacrifice here, apparently not including the UAW, but everybody needs to sacrifice. What's alarming about this is that most of the secured bonds were held by a bunch of big banks. And you can't point to a smoking gun, but it's pretty clear what was going on there was that some of America's biggest banks rolled over and accepted basically being mistreated in this very high-profile bankruptcy case, and it cost them, billions of dollars. Why might that be? Well, it's probably not just a coincidence that most of those same banks had been recipients of huge amounts of TARP money, and I don't know if we'll ever know the back scene story, but we know is that these creditors rolled over at the request of the Obama administration, all the TARP banks, and then they were used as a club to browbeat all the other creditors into submission. I think that's a very troubling component of these cases. The way in which that sort of once you give money to these banks, all these political strings come attached to it, and I think we saw some of that in this case.
Why was GM different in that regard with their secured creditors? What?
The Obama administration's never tried to justify why secured creditors got paid in full in the General Motors case, and they did. They got paid in full, which is typical in bankruptcy. The only difference seems to be is that there weren't as many of them. The General Motors had primarily unsecured bonds rather than secured credit, and so as a result, they were able to pass through bankruptcy. And one of the things we've seen is that the implications of violation of absolute priority were really quite profound, which is there was a study that came out about a month or two ago where they found that after that happened in the Chrysler case, there was an impact on the credit markets, which is that borrowing costs for companies and highly unionized industries went up, that there was a political risk that started appearing in the market where you had where companies that had the uncertainty of if they filed bankruptcy, there might be political intervention, made it increase the risk of lending those companies, and as a result, their cost of capital increased after that.
No, that's an interesting point as well. I mean, and certain scholars have even tried to drill down the precise cost in these markets from the process. I wanted to ask you briefly though, how does TARP figure into this? Because my understanding is Chrysler and GM are both bailed out with funds from that program. Yet the legislation said that it was to be used for financial institutions. How was that justified?
It's a pretty. I've never seen a convincing justification, and it seems pretty clear to me. And this will sound somewhat dramatic, but it seems pretty clear to me, and I think most fair-minded people have looked at it, that it was illegal to use TARP funds for this, and I think that's quite problematic as well. And we should keep in mind that it was President Bush and Secretary Paulson who originally authorized TARP funds to be used. And if you want to sort of get the whole story, remember that what happened was originally General Motors came to Congress with their tin cup to get a bailout. And the House of Representatives, on basically a party line vote, had voted to approve a $14 billion bailout. The next day, the Senate, though, voted that down. And there's a couple things we could take away from that, which is, number one, if Congress had already thought that they had authorized money to be given to auto companies through the TARP, why were they voting on an auto bailout? And in fact, after President Bush did that, 26 senators wrote a letter basically complaining and saying, we did not authorize TARP money to be used for this. And as you said, the TARP is very clear in what it was going to be used for, which was for financial institutions to buy troubled assets. And in fact, if you read Steve Ratner's book, which is an experience I do not recommend, he's the car czar who ran this, he quotes Hank Paulson as telling General Motors when I first came to him, you are not going to be able to use it, referring to the TARP. You will probably need to go to Congress. But then as soon as they decided to bail out the company, Bush and Paulson didn't hesitate at all to simply take money that was not authorized for this purpose and give it to the auto companies, and that was never actually able to be challenged in court because the bankruptcy court said that nobody had standing to challenge it.
So yeah, it's just really standing screens the court from ruling on the merit of this entire
That's
process.
That's exactly what happened here, right? It's that, yeah, they basically said that there were nobody involved in the case who could raise that complaint. And I think, one of the things that I think is troubling about that is that there was a long period during the Bush administration of, an assertion of executive authority in times of discretion in times of national security, and that. And one of the things I think we saw in the auto bailouts was that there are precedents that can be set from that. If we're not vigilant about the rule of law, we don't know exactly where that might spread. And I think this may have been an example when they, I just think, blatantly broke the law in using TARP funds for this purpose.
It seems so. Is the solution to this, and you started to talk about this earlier, is the solution really what's happened in, say, public debt markets, loans for companies, credit default swaps, et cetera, for firms that fit these sorts of facts, highly unionized firms, this is another component as well, firms that seem that if they go under, they won't be able to make their pension obligations, and thus, of course, the federal government has the pension benefit guarantee corporation, so that's a cost that taxpayers would incur. Are these firms now in the situation where to actually get funds to run their companies, either in equity or debt markets, that they're having to pay a higher price? Is that really the true fallout from this?
Yeah, I mean that's obviously a fallout. That they have to pay more for this for money, and that obviously impacts the entire economy in terms of how that operates. But there's also sort of a more general point here, right? Which is that if you start getting government meddling in propping up companies and that sort of thing, where does it end? And if you keep the government sort of supporting, if the principle here is, which I hope it is not, that the government should try to prop up failing companies for political reasons more than anything else, the impact of that is, sort of our old friend Bastiat, what is seen and unseen, right? Which is the impact of that is that it keeps as I was saying earlier, human capital, physical capital, and financial capital deployed to less efficient uses than it should be redeployed elsewhere in the economy, that you're focusing on supposedly saving jobs. But the real cost is the jobs that are never created, because now you've got a system where access to capital is more expensive and that sort of thing. And so that over time can sort of strangulate dynamism in entrepreneurship in the economy.
Let me ask you this question. So if we think about a prior example of this, sort of 1979, Lee Iacocca, in conjunction with the mayor of Detroit and a lot of grassroots organizations, kind of wages a months-long campaign within the Congress and in public opinion to secure a loan from the federal government to keep Chrysler going. But this was really seen as an extraordinary event. And also in that case as well, the union took a substantial haircut, which I think it's fair to say did not happen in 2009 for either GM or Chrysler. But going back, Iacocca does this. He gets a lot of credit after it happens, after Chrysler turns around. And we kind of look back and say it was the right thing to do. I mean, or that's a consensus view. We've got this case. We've got the bailouts, obviously, of the financial institutions, or should we say they were actually, many of them were actually forced to take money from the federal government. A lot of them didn't want to do that. And then we've got now the continued news of the alternative energy investing program. Something like $38 billion have been spent at this point. Have we really exhausted resistance to this sort of thing? Do we now actually look at the government even as a pretty good backstop for large companies that might have a huge impact on the economy, or also as a venture capitalist? I mean, are we now in this realm of government by discretion, government by waiver?
Well, I think that's the real issue here, Richard, which is that there was a very subtle but important change that came about between the Bush approach to this and the Obama approach to this, which is, subject to everything I said earlier. The approach that the Bush administration took was, was essentially this is a necessary evil, that they felt like because these companies had not been prepared for bankruptcy, they needed to give them a little bit more time to get their act together, and they were going to just kind of kick the can down the road so that the Obama administration could deal with it. But their approach was somewhat reluctant. There was a necessary evil. What I think is a very important change in attitude came about with the way President Obama has been touting this as part of his reelection campaign, which is he trumpets this as a positive success, which is to say that this was a roaring success, and the government did things here that couldn't have been done through the private market and the rule of law, right? Which I think is wrong. But that's a very different change in mindset, and I think it is exactly consistent with what you are saying, which is if this is a success and that we believe government is good at this, then he's basically proposing the government should do more of it. The government should be more of a venture capitalist. The government should be picking winners and losers in the marketplace. The flip side of that is obviously politicians love that, because one of the things that was so bad, and why I say that these companies actually came out of bankruptcy worse off than they would have been had they simply filed a regular bankruptcy, was all the political tinkering that went into this. It's often said that after General Motors filed bankruptcy, they got 535 new members of the board of directors, right? 435 House members and 100 senators. And what we see checkered throughout these cases is politicians intervening on behalf of auto dealers in their district. Barney Frank intervened in order to keep open basically an obsolete manufacturing plant in his district. We got the Montana delegation intervening to protect the palladium mines in their district. And so what we saw here was this sort of buddy-buddy sort of relationship between the politicians who like the ability to grab a hold of these companies and do political things with them, and, as you were saying, the ability of the companies to basically go to the government and basically use them to prop them up.
Let me ask you, was the problem here that these are massive companies, and obviously within, say, the American story, the automobile is a huge part of that. I mean, if you think about commercially, but also think from movies, TV shows, sports. The car is central to some sort of identity of Americanism, and also the way in which these companies are seen as just part of America. We go back to Ford in the early part of the century with the Model T and et cetera. I mean, this is kind of the factory process. So it seems to me that there's some sort of American mythology going on. There's also the size of the companies. Do we have experience with companies this large going into bankruptcy and coming out on the other side in a position to compete and grow again?
Well, there's two things to say about that, right? Which is that the one is we do need to be aware of the moral hazard problem that is created here. I mean, after all, Ford was in trouble many years, 10 years ago also, but Ford basically bit the bullet, got some good management, and got their act together. And what we saw here instead was Chrysler and General Motors kind of both kept dithering, and some discipline of the marketplace is necessary. And so what you have here is essentially a soft landing where the UAW doesn't have to take any pay cuts or bring themselves in line with their competitors, and all these other things that happen. You're really creating a precedent for the future that is very dangerous. So it's not just a one-off. You've got these situations, but it is also the case. Yes, I mean these were General Motors was a huge bankruptcy. There's no doubt about it. But it wasn't, in some sense, a particularly complex bankruptcy. We've seen very complex bankruptcies. We've seen bankruptcies of very large companies, department stores like Macy's, airlines, that raise a lot of these same issues in terms of unionized workforce and public confidence and everything else. So, I don't think that those arguments were particularly pressing here. What the companies had tried to argue is nobody would buy a car from them if they filed bankruptcy, and I just think that was never a very plausible argument. They did eventually file bankruptcy, and people kept buying cars. And I think that if it had been clear that they were going to reorganize, that wouldn't have been a problem. And so I think that the argument that straight bankruptcy, wouldn't have worked here, I just don't think is a very strong argument.
Right now, it seems there's a kind of a counter narrative in the sense of the 2010 elections. You have a Republican Party that, at least in rhetoric, sounds more like Calvin Coolidge, not the party of George W. Bush. There is at least a very kind of a palpable public opposition to a lot of the things that happened after the election or after the 2008 crisis. Is that something you can point to, or is that still largely something that can't drill down, given the power of special interests and the power of what's happened in Washington? Are these things difficult to reconcile, difficult to dislodge because of that part of government and the ability of, say, a minority interest, given the expected benefit? Are they able to protect themselves in these sorts of situations, exacerbated by emergency and a long economic downturn? Is there any sort of fruit or hope to point towards after this?
Well, I think the people have tried to understand these cases. If you just focus on these bailouts, and one of the things is it's a little bit technical, but I think people have the sense that something went wrong there, specifically. But more generally, what I think that the auto bailouts and to some extent the banking bailouts as well illustrate is what I think of, and perhaps other people are recognizing this too. But I think it illustrates something about what I think of as Obamonomics, which is often thought of as sort of a watered down version of socialism. But what I think we see in these cases, and we see it in the whole range of things that you referred to earlier, the green subsidies and the sort of cozy relationships between General Electric and the government and all these big banks and the government and everything else, is that what I think we are seeing is sort of a return to the economy of the 60s and the 70s, which is sort of an alliance of big business, big government, and big labor to sort of divide up the economy among themselves. And it's a model of the economy which is rooted in sort of stagnation and perhaps even managed decline. And I think that what people are recognizing is that that's not the model they want to live under. That's a model in which what gets sacrificed is entrepreneurship and dynamism and freedom and everything else. And I mean, if you just look at Obamacare, for instance, right? I mean, that is a remarkable piece of legislation in the sense that they managed to get Big Pharma to sign on it. They managed to get the big health insurance companies to sign on to it. They managed to, they did a lot of different things there that basically were payoffs to big business who essentially, went along with it. And I think that's what people are noticing. I think that's what people are discovering is that this sort of cozy relationship between Washington and in the economy is not working out for the rest of us.
Yeah, I mean, that seems to be, if one thinks about, say, the Tea Party, its core group would be middle class, upper middle class, businessmen, families, et cetera, who, we could say like stable, financially stable, even financially successful, but certainly not at this level of, say, direct access to centers of power in Washington the way executives of GM or say alternative energy companies in Silicon Valley, et cetera. They don't have that level of access, and they sense that something is being lost in this process of government. That seems to be kind of you think about the self-interest of the Tea Party. To my mind, that seems to be at play. Let me ask you kind of just a basic philosophical question. In a time of economic uncertainty, or let's say economic uncertainty, but John Locke articulated the principle that the executive needs prerogative of necessity in times of emergency, because the law can never fully account for all of these things, given limitations of human knowledge. Are you being too restrictive of what government needs to be able to do? Is the rule of law something that we don't want to be a hobgoblin about it? We actually want to be able to maneuver and to adjust, if nothing else, just to accommodate for democratic demand, even if it's not, say, economically efficient and effective.
Well, it's a fair point, and obviously I'm very skeptical about the assertion of executive discretion during periods like this, and that's for a couple of reasons. Which is, first, I think that it rests on an assumption which may be true, but is largely unexamined, which is the notion that somehow an economic crisis and a national security crisis are the same thing. And I don't think that's necessarily the case, which is that what you have when you have an economic crisis is sort of a Hayekian sort of moment, which is that the economy is highly disequilibrated, and people need to be able to sort of reestablish coordination so that economic affairs can run smoothly. And I think one of the things we saw that during the crisis, which has been counterproductive, was sort of a pell-mell sort of approach to addressing problems, which I think was counterproductive to recovery. And I think that what people were looking for was stability, so that they know what the rules would be. And I think what we've seen in the past few years is sort of layering stability, instability on top of instability. I think the second thing that's really important to keep in mind is that the rule of law, in addition to providing a foundation for private actors, as I was just saying, to figure out what's going on, the rule of law is also designed as a way of restraining political opportunism. And of course, the classic example was, the famous line by Rahm Emanuel, never let a good crisis go to waste. And that's kind of the political approach to these things, which is the rule of law is there to tie those guys' hands precisely because we know that they're going to seize political opportunities when they get it. And so I think that's the other thing that we've seen here. So what I take away from this is, if anything, what we need in a time of economic instability is adherence to the rule of law, so people know what the rules are and basically allow people to reestablish coordination, to be able to make investments, to know what the rules are. And instead, what we've seen is they take their money and pull it out. The final thing I think that's really quite troubling about this, and Dodd-Frank is a good example of this, and it follows on the history of the Great Depression as well, which is that once we get these assertion of discretion and authority during the crisis, we don't put the genie back in the bottle, right? Which is, Dodd-Frank is a wonderful example. It basically basically takes all of that discretion that the government exercised during the crisis and codifies it. It basically has 2,400 pages of government discretion to do what they want to do, and basically, when people look at it, what they see is it's going to be it's going to create a dynamic that is going to entrench too big to fail, create the other advantages for the largest banks, and probably promote consolidation of the American banking system. The rule of law is there to protect the little guy. We often forget that. The big guys, the Citigroups, the Goldman Sachs, they're the ones who can hire the lawyers and play the game to find the loopholes in the law and always advantage them. The rule of law is there to protect the rest of us who can't do that.
Do you see, I mean, you mentioned Dodd-Frank. My understanding, and I can't go into the level of detail, not having looked at it in depth, but my understanding from things that I've read are you largely have several boards of power that are largely unaccountable to Congress. I mean, I think there is some sort of cursory review there, but largely, I mean, their ability to seize an institution they deem to be a macroeconomic threat or something like that to our economic stability is really unprecedented. And also, the things they can force companies to do if they think that. Is that your understanding? And is there any sort of overview or constitutional arguments there that people can make that would suffice in a court?
That'll be interesting to see. Is we're expecting a legal challenge to that exactly on that ground, which is whether it's the non-delegation doctrine, which basically says that the Congress has to provide some policy guidance for these things, or whether it's under the case that the Supreme Court decided a few years ago called the Free Enterprise Fund versus the PCAOB, which is basically separation of powers and requires some accountability for people who are making major decisions, and it's expected that there will be lawsuits associated with this. I mean, the best example is the one I think that I've studied, which is the Consumer Financial Protection Bureau, which is this single director agency, which is set up inside of the Federal Reserve, but is not accountable to the Federal Reserve. So it's something that I think is relatively unprecedented, which is an independent agency inside of another independent agency. They get a guaranteed budget from the Federal Reserve. They don't have to go to Congress. And they've got vast powers to regulate basically every consumer credit product in the economy with very little oversight. And in fact, the only oversight, the only role Congress had with that was confirming its director. And if you followed the news, that was even bypassed when President Obama did a recess appointment, which could very well have been illegal as well, of Richard Cordray to head up that bureau. So it's a good example of exactly the problem that Dodd-Frank creates.
The Consumer Financial Protection Bureau, you mentioned being layered within another independent agency. Now, is that different from the original creation of Peekaboo? That was the Public Accounting Company Accountability Board. Because my understanding is there was a similar setup there that was ruled unconstitutional. Or am I not remembering correctly? I don't know. I was just
the decision in the Peekaboo case, Free Enterprise Fund versus Peekaboo case, was pretty narrow, but it's in specific terms. But there's a lot in that case that suggests that there are major problems with the CFPB as well. And one of the reasons it was narrow was because they were able to get rid of it on a particular ground. But there is language in there that suggests that the kind of unaccountable power that the CFPB has, and it really is, as far as I can tell, the sort of simultaneously the most powerful and least accountable governmental entity we've ever seen. I think that there are a lot of problems with that agency.
Just closing here, thinking largely, it seems for this not to be successful precedent. I mean, of course, public consensus can view this as a success, in particular if these companies seem to be, able to hold their own. But also, it's almost as if we need a moment where an executive or the Congress actually stands up on constitutional grounds, on grounds of the rule of law in an emergency situation, and actually defends inaction. or something along those lines. We do have some precedent, in particular with Calvin Coolidge during the 1927 flood, really refusing because he thought it would fall out of his purview to spend federal dollars for all of these the tragedy in the wake of that flood, and he defended his response. And similarly, he rejected the McNary-Halligan bill, kind of a forerunner to the Agricultural Adjustment Act. It seems, in the way he did it, was a very public, constitutionally grounded speech. It seems to my mind that's the only way you would rebuke this sort of a situation, this being kind of a practical response, and it being received well by the people. And thinking of rehabilitating the rule of law, I don't know how else you do it in a democracy. Have you given thought to that?
I think that's right. And, one of the things that was quite striking about this, and in many ways quite surprising, was that when the auto bailout bill came up, it was really quite impressive that the Senate actually voted it down. And the reason they voted it down was because there wasn't enough accountability in there. So, for instance, one of the requirements that members of the Senate had been insisting on was that the UAW would have to take a haircut, and that the UAW would have to have their wages and benefits adjusted to the level of the transplants. And it's not surprising that one of the people who was leading that charge was Senator Corker from Tennessee, and a number of the southern senators who have Honda or Toyota or Volkswagen plants in their states. Push for that, but I thought it was really quite courageous in some sense that they were willing to vote it down. And then the problem was that the president went ahead and did it anyway after they voted it down. But I think that's right. I mean, I think there has to be some people who are willing to say no. And I think one of the other lessons from here is that, number one, General Motors basically played chicken with Congress, and I think it's significant that they said, we're not going to make preparations for bankruptcy, and we're going to basically force your hand. But the second thing I think we take away from this is what happens if you're in California and you're the state of California. What are the lessons of General Motors and Chrysler as to whether or not California should get their fiscal house in order or just basically charge full speed ahead and hope for a federal government bailout? It seems to me that California must be thinking of itself as being too big to fail at this point, and quite a ripe prospect for a federal government bailout. And I think those are the kind of problems that you run into once you start down this road.
Yeah, no, that's very interesting. Debts that cannot be paid will not be, and that California seems to be clearly in that boat. Professor Zywicki, thank you for being with us today.
Thanks, Richard.
This is your host, Richard Reinsch, and you have been listening to a podcast that can be found at libertylawtalk.org, where you can subscribe, comment, find other episodes, and links relevant to today's conversation. Our email address is mail@libertylawtalk.org.